A parent, custodian, and/or guardian who has the legal right to custody of the child can meet with an intake officer in the juvenile intake office to prepare a child in need of supervision or child in need of services or CHINS petition. Regarding a child in need of services petition, the intake officer will prepare a petition only after finding that the parent and the child have made reasonable efforts to use or attempt to use treatment and services available in the community and have exhausted all non-court remedies available to them. A child in need of supervision petition will be filed only after an intake officer determines that, while subject to compulsory school attendance, the child has habitually and without justification been absent from school or truant, the child's behavior is a threat to his or her life or health, including running away from home, or the child committed an offense prohibited by law that would not be a criminal act if committed by an adult. If the intake officer does not find that the child is in need of services or supervision, a petition cannot be filed with the court. If the intake officer concludes that the child is in need of services or supervision, a petition will be prepared. After a CHINS petition is filed, the child has a right to due process. Specifically, the child has the right to have a hearing where they can present evidence and arguments in their favor. The child also has the right to an attorney, who can be appointed by the judge. If necessary, the judge can also appoint a separate attorney called a guardian ad litem, who will meet with the family, visit their home, investigate the allegations, and bring their findings back to the court. At trial, the parent that filed the CHINS petition must demonstrate through evidence that the child needs services, is not attending school, ran away from home, or committed a status offense. The child's attorney and guardian ad litem can question the parent about the allegation. Then, the child will have the opportunity to testify and present witnesses and documents contesting the allegations. If the judge finds that the child is in need of supervision or services, the matter will be scheduled for a separate hearing called disposition. The purpose of the dispositional hearing is to determine what services and conditions should be imposed that are in the child's best interest. Instead of a trial, the child can admit the allegation made by their parent. The judge will then schedule a hearing for disposition. During the period between adjudication and disposition, a group of professionals called an interdisciplinary team will convene to create a treatment plan for the child. Participants will include the child, parent, teacher, probation officer, if appointed by the court, and mental health treatment provider. The team will meet and determine what services are needed to help the child progress. Then a report is written summarizing the team's findings, which is sent to the judge for consideration before the dispositional hearing. At disposition for child in need of services cases, the judge will decide what services and conditions should be imposed. Services can include therapy for the child and the family, substance use treatment, or transfer to a residential treatment facility. In child in need of supervision cases, the judge can excuse the child from the requirement to complete compulsory education. The judge can also appoint a probation officer to ensure that the child remains in their home, as ordered by the judge. After the dispositional hearing, the parties will return to court to review the child's progress. The judge may impose additional conditions, supervision, or services as needed. The information provided in this video is not intended to be legal advice and should not be relied upon for that purpose. You are strongly encouraged to speak with an attorney so that legal proceedings and the effect of legal documents and orders can be explained. For additional questions and information, please consult the Self-Help Resource Center located in the Fairfax County Courthouse Law Library on the first floor of the court complex.